Joining us to take that conversation further is the Chairman, Conference Planning Committee of the NBA, section on Public Interest and Development Law, SPIDL, and that is a former first Vice President of the NBA and former Chairman, NBA Human Rights Institute, Mr. Ikeazor. Thank you very much for joining us this morning.
I'm pleased to be here myself.
I think we should begin from where that conversation ended.
Yes.
It's done and dusted now, but just on education. One of the issues that your learned colleagues often came up to tell us is that, look, there is a difference between a public officer and a judicial officer. But how about a judicial officer who is in public office? The CCB is for public officers as the NJC is for judicial officers. So there's still a dichotomy there. Is there a difference between a judicial officer who is a public officer? I don't understand, because that's one of the major contentions, in the Justice Onnoghen case.
Well, I would rather say that the CCT, the Code of Conduct Tribunal, has the power to look into everybody in public office, and that includes the justices. I rather say so. I think the distinction or the contention over distinction between a judicial officer and a public officer is a bit superfluous. Okay. Yes. Rather, my view is the Code of Conduct Tribunal has the power to look into whether somebody in public office has fulfilled the law with respect to declaring his assets on the Code of Conduct form, which everybody who works in the government at a certain level is expected to. But the question is whether the CCT did not overreach itself in the matter of Honorable Justice Onnoghen, CJN Emeritus. They did. They did in the sense that they went on and declared him unfit to hold office. In fact, they even said they had removed him. The CCT said, recommended his removal or even declared him removed from office. I'm not too sure what language now, but they overreached themselves. It wasn't within their remit to do that. That's number one. Constitutionally, it is the NJC which could have recommended the removal of CJN Onnoghen, and it was necessary for his removal to go through the Senate. But the Senate was deliberately left out of the equation, and so what happened to Onnoghen remains an illegality.
So do you agree? I think one of the major talking points from yesterday was someone saying that the NBA and judiciary failed the former Justice Onnoghen. Do you agree with that?
Well, Senator Abaribe said so. Incidentally, I was there. And my view, I wouldn't say the judiciary failed. Like Ozekome said, the judiciary is defanged. The judiciary cannot fight for itself. It's the bar. So I will wholeheartedly agree that the bar could have done more.
That's the NBA.
The NBA could have done more. In fact, the NBA failed to exercise itself as much as it should. The bar was divided on partisan lines. But I would rather say to Senator Abaribe, you're shifting the blame to the Nigerian Bar Association, that Nigerian Bar Association did not do what it should do. What did you, the Senate, do? Were you defanged? Are you required to wait for the bar? If the president acted unconstitutionally, which he did, the president of Nigeria acted unconstitutionally, what is the duty of the Senate where a president acts unconstitutionally. If the president bypasses, neglects, or tramples upon the Constitution, should the Senate not have begun impeachment proceedings against him, even if the proceedings will fail, to make a statement that, hey, you don't do some things. So, yes, Abaribe is correct that the bar should have done more. We are the first to admit, and you saw the ovation from members of the bar when he said we should have done more. Our leadership ought to have done more. And I would like to know why they didn't do more. I was VP when Akeredolu was the president. And anybody who was an adult in Nigeria knows that those were the golden years of NBA activism. Akeredolu administration challenged every infraction, including the refusal to transmit presidential authority to VP Jonathan, as he then was, when the president was away. We challenged everything, but that should have happened. But the Senate itself failed.
So
and that's what Abaribe left out.
Okay. So this indication or admittance, because this is the second time we're hearing that, you know, the NBA could have done more. What is responsible for the seeming lax, if we can use it for want of a better word, of the NBA now?
That will be difficult for me to answer.
But yeah, you're an authority in NBA. So as this...
the president of the NBA, Paul Usoro, SAN, has done very, very well in a lot of respects. But and indeed, he has spoken up on a number of issues in the country. And he spoke up on the Onnoghen issue. And he called for a strike. He called lawyers to boycott the courts.
But we saw what happened with that.
Yes, many lawyers did not. Even though many more did, but many did not. So we cannot really criticize him. But in my respectful view, he has not been as activist as Akeredolu, or as even J.B. Daudu. J.B. Daudu was activist. Olisa Agbakoba was activist. And my understanding of the situation is twofold. Number one is the presidency of the NBA is constitutionally a powerful office, and therefore the president of the regime of anybody is dependent on the attitude and temperament of who occupies the office. Some people are more activists in the human rights direction than others. Some people are more managerial. They want to concentrate on building the institutions of the NBA. So that is the situation. The second reason I would say is that there is a court case which I'm not able to pronounce on because it is in court against the president of the NBA, and that complicates issues. Some lawyers feel that it is a subtle blackmail to limit his ability. I don't know.
Doesn't that then also put the whole idea of human rights and rule of law, you know, at bay, you know, so to speak? If the NBA, who is supposed to be, as you said, an activist for a larger number of the people, if the NBA is not able to do what it is supposed to do, as and when due, rule of law and human rights will continue to be in abeyance.
Let me rephrase you. In answering you, I will rephrase you. NBA needs to build institutions which, irrespective of the temperament or thrust of the president, of who occupies the presidency, will go on and carry on regardless. That's what we need to do. I was chairman of the Human Rights Institute. And as chairman of Human Rights Institute, I was given the authority by my president, Oluwarotimi Akeredolu, to speak on human rights issues, to handle human rights issues. The Human Rights Institute is only there now on paper. That's an institution that, irrespective of the president, if it was active, it should be able to address Human Rights Institute, whether the president is a human rights man or not. We have the section on public interest and development law. MBA is built upon 3 sections: business law, law practice, and public interest and development law. My understanding is that this institution should be able to address issues that come under their remit. You know, and that is where we in the MBA need to do something. We need to strengthen our institution. Our institutions, with the greatest respect, could be stronger.
Right. Now you talk about Speedel, which is your jurisdiction. I'm using that term. So what are you doing? Because you have said that it appears as though the NBA has been defunct. But if you look at statistics, at least 105,000 lawyers in Nigeria.
Did I say that the NBA has been defunct?
Sort of. You said that it appears as though
the judiciary has been defunct.
Has been defunct, rather.
Well, not has been defunct. The judiciary is traditionally a defunct institution. It's not. It can't go on strike. It can't speak for itself.
Okay, which means it lacks the bite, as it were.
The judiciary does not lack the bite to give judgments and pronouncements, but it lacks the bite to discuss, to defend itself. If you abuse a judge, if you accuse a judge of corruption now, he can't address the press.
Okay, so let's look at
It is the bar that will do it for him.
So now Nigerians.
And if the bar begins to accuse him also of corruption, and I do have a problem with my learned senior and respected friend and colleague, Falana, S-A-N, saying that the CJ of Pakistan was not removed for corruption, but Onnoghen has millions of naira. Well, when a judge has millions of naira, which you can't explain. Well, with the greatest respect, it was necessary for Onnoghen to have gone through a process of trial, maybe suspended from the office, with the Senate in the picture. And then let us now know that the money in his account can be explained. I can tell you, in my experience, I've been in practice for 34 years. I've done nothing else but litigate in courts. In my experience, I'm part of the justice delivery system. You cannot say that because there are millions found in the account of a judge that he's a corrupt man.
The problem was not that the money
but that they were not reflected in
that they were not reflected and they couldn't be accounted for at the time. But then you also mentioned the fact that he should have been suspended, but that's exactly what happened. He was suspended.
And he was suspended, but then the process of eventual he wasn't even removed. He resigned, and we know he was compelled to resign. That is the fact out there.
You know, one of the things that many people
to resign.
One of the things that many people say is that the fact that the bar, so to speak, is, in a manner of speaking, divided against itself is also the reason why some human rights cases or rule of law is difficult to champion. Because, just as you are saying now, on the one hand is Mr. Ozekume saying something, on the other hand is Mr. Falana saying something, and you are, making this, similar statement on the same, case now. So the public is kind of confused. Where exactly are we supposed to go now?
Well, it goes with the terrain. The bar is not divided against itself. But we are lawyers, and where 2 or 3 lawyers are gathered, there are 2 or 3 different opinions. And that's the way it is with us. You have an idea of this, you are in court, you are canvassing this view, your learned friend is
So there is no right or wrong?
Well, there is right or wrong, and that's in court, it's for the judge to determine the right or wrong. And if you're not satisfied, you appeal. But now, I don't think we are divided against ourselves. But I think that it is the duty of the executive of the Nigerian Bar Association to collate all views and stand on one side.
Well, we are hoping that you'll be able to do that and champion that, really speedily, because, look at the prison statistics that we talked about this, some not too long ago as well. The fact that there are about 70% of the people who are inmates of different correctional facilities who are awaiting trial. Now, the human rights community, of course, which you are very well aware of, have accused, the lawyers of not being able to do what they need to do to get their people out of these situations.
I'm happy you will reason this, because the truth is, it is a failure of government and not a failure of the bar or the judiciary. For example, in the state in which I practice, Enugu, the judges are maybe 20 or 21. A judge has 500 cases in his court. He's a human being. He records longhand. There's no electronic recording. He records one longhand. He has to hear arguments. He has to go back home and write rulings and judgments. At the end of the year, how many can he do? Now, if you want to clear the prisons, and I've said this again and again, you need to have a minimum of 100 judges in every state, which the National Assembly and the executive arm are not willing to give teeth to.
Shouldn't it be
Let me explain
championing
this.
that?
Let me explain. Yes, we are speaking about this. I'll explain how it works. 2010, I went to Vancouver for the International Bar Association conference. And we said, let's go visit the courts. We got to the courts of Vancouver, and there were 60 high courts. And across the road were 60 magistrates courts, a complex, 60 high courts here, 60 magistrate courts there. So we asked them, are these the courts for the entire state of British Columbia? They said, no, it's for Vancouver alone. That Victoria, the capital, has a similar number of courts. 60 courts in one city. And we sat in a court and listened to the cases. One case on the court list, only one case. And the judge listened to the case from start to finish in one day. Now you have a situation where 20 judges, how won't the prisons be full? If you have 100 judges, and for a country which produces 5,000 law students every year from the law school into the market, why can't some states, why can't Lagos have 200 high courts? So a judge can do only 2 cases in a day. If you try this, in 12 months, the prisons will be empty of people who are awaiting their trial. They'll be acquitted or convicted.
If I mean, this is interesting. You're talking about this. And, you know, earlier when I asked, why aren't you championing this? Because if you count, I mean, let's take the executive, for example. I mean, if you count 1, 2, you find a lawyer in top echelon of power. Take the National Assembly. That's the legislature. I mean, you know what the statistics are. I'm not even going to judiciary because that's obvious already. So you have the numbers, as it were, to champion this cause and see through. So it begs the question, I mean, we've seen these lapses. We've seen time and again. So why do we still have this situation? You should be, I mean, you are sort of in charge, if I can say that. So you should have the ease to achieve some of these things you want to achieve.
I don't want to keep on defending the indefensible. The truth is that our lawyers in the National Assembly, in my own opinion, have failed abysmally. There's really a problem with the with lawyers when we go into office. I wonder why. I know there's a lot of people who answer barrister, but who have never practiced law for one day. That is one other situation you have on hand. The fact that somebody is a lawyer does not mean that the person is acquainted, is abreast with the challenges of the justice delivery sector. They go to law school and put on the barrister as a chieftaincy, and then they do other things. So there are a few people who have seen. I mean, sometimes I look at chairman of Judiciary Committee in the Federal House of Reps, chairman of Judiciary Committee in the Senate. Sometimes you see the person has never practiced law, but because he has an LLBBL, he occupies the position. But I want to ask some of those who have practiced law, what did they do? I know a few who have practiced law. What did they achieve in that respect? So I agree with you that the bar has not done as well as it should in the National Assembly. And I recall when we were in office, when we were in NBA office, we had this Legislative Advocacy Committee, which was chaired by J.B. Daudu, SAN. And J.B. Daudu, who later became the president, J.B. Daudu was in the National Assembly every week, every other week, trying to push justice sector-related issues. And
is that happening now?
I wouldn't know because I'm not in the executive, and we don't receive. But I'm a member of the National Executive Committee, made up of about 300, 400 of us. We have never received, to the best of my knowledge, reports saying that this is what is going on.
Doesn't that also say, I mean, from some of the things that we hear you say, doesn't that also say that there is a challenge even with communication among the Nigerian Bar Association? Consequently, some of these things that you are raising, you cannot really be giving teeth to, because even the members of the bar themselves are not particularly comfortable with the way things have been run.
Definitely, we could, the bar could have, we need to recalibrate. There's no question that we need to reinvent the Nigerian Bar Association. I don't think there's any argument about that. We need to. This is an internal thing which I'm not supposed to come here and wash
But then,
our leanings in public, but we need to.
If this is going on, one of your members, was here yesterday telling us that, look, people should be able to report any infraction of a lawyer. So if, to the NBA disciplinary committee and all of that. So if this is going on, what confidence does the public then have to come to the NBA and report anyone?
Well, we cry out to the public, please do not shut your eyes to infractions of lawyers. Report to the NBA. Do so. And but I think that the NBA has done a lot. There's no reason for loss of confidence. I'm being frank with you here that we need to reinvent ourselves. Particularly starting from the Onnoghen saga, we reacted, but we could have done more. But I don't want to blame the president of the NBA because the bar was so divided. And perhaps I should say we were divided along the lines of region. It became regional. It wasn't easy for the president. He comes from the same zone as Onnoghen. And his zone and the Southeast all boycotted the courts. And we had a non-boycott of the courts from the zone the president of Nigeria comes from, and from the Western zone, which is basically an APC zone. Of course, there were some pockets of compliance in these zones. So it's not very easy. It's not very easy because there are some, when it comes to politics, my view is that the bar will be divided because we all are political animals with our feelings. But my additional view is that the president of the bar, since we have entrusted you with the presidency, we have to swim or sink with your views. And so if your view is this way, even if half the bar, their view is this way, we must follow you must assert your views upon the bar. And I saw it happen when Ikeazor was the president. We came to NEC meetings, people got up, shouted on him and abused him, and he went on and asserted his own view because we had entrusted him with the mandate. So this is where I think the current administration could have been much more emphatic and not have necessarily allowed itself to try to accommodate all the views in the bar.
Now, you said that the NBA needs to recalibrate. How urgently must that be done, and what is the consequence if it's not done that urgently?
We have our annual general meeting tomorrow, and we are looking at amending the constitution of the NBA. The process of recalibration has started. We want to see how we can remove institutional deficiencies to the NBA achieving its goal and objective. So that has started.
Okay. Now, the theme for this conference is facing the future. What exactly does it mean?
Well, there is a brand new future out there. The way law practice is practiced. I was in Australia 2017 for the International Bar Association conference, Sydney. And we went on a tour of law firms. And we saw law firms with 500 lawyers, 300 lawyers. I don't know if there's any law firm in Nigeria that has 100. And then we asked them, can we see your library? And they said, we don't have libraries anymore. There are no book libraries. One law firm showed us a shelf. So we just left this so that future generations can know what a library used to look like. Everything is e-libraries. They say they are connected to the library in Harvard, libraries in UK, in the US. They pay subscriptions. They can access all books online and so on. Now that is the future we must face. I am a publisher. I publish the Court of Appeal reports. A few times, lawyers have reached me to say, we are sorry we can no longer buy your law report. We want you to go online now. We don't have space in our library. So there is a new outlook. There's a new outlook. You also find that law practice is now going beyond nations. We must face the fact that lawyers in the UK, can they have access to briefs in Nigeria? Already it's happening. Accountants are subtly beginning to practice documentary law transactional law through the things that come upon their desk as accountants. We have to face the future. How does the bar react to this? How do we up our game so that we remain relevant? You probably have heard the story of how Nokia went out of business because they didn't keep up with the trends. If we don't keep up with the trends, we'll go out of relevance and reckoning.
I'd like us to talk about young lawyers that are coming into the profession, especially because they are also the future.
Unfortunately, we need to take a break now.
But I'm interested in that. Young lawyers.
Oh, yes. We need to take a break now. When we return, we'll take it a step further. Stay with us. Mr. Ikeazor Karaiwe is still with us, Chairman, Conference Planning Committee of the NBA.
MBA SPIDEL.
NBA SPIDEL.
Yes.
That's the
NBA SPIDEL conference.
Section on Public Interest and Development Law. You wanted to take him up on
Speaking of SPIDEL and the future of law practice in Nigeria, we're talking about young people, the fact that they are the future. And what they see now will depend or will largely influence the kind of future they birth, the kind of trends they see, what they see senior lawyers practice. I understand that SPIDEL tries to encourage people to take up pro bono cases, try to do things for the interest of a common man, people that cannot afford, to pay lawyers. But then you see lawyers this day saying, we need the money on one hand. I mean, we need to pay bills. Going into pro bono does not exactly pay the bills. So how do they balance this for young lawyers, that is?
Yeah. I remember several years ago, I went for an interview for a U.S. visa. And the U.S. visa officer asked me, what area of law do you practice? And I started off with human rights law, and she interrupted me, does human rights pay your bills? So that's
I'm sure your answer was...
well, I smiled. I said, well, I do other things. I also do. She said, aha. I mentioned the other areas of practice. She said, aha. So I think it is globally known that human rights work and public interest work has no financial reward. So to answer your question, young lawyers have to practice, they have to feed, and can they really survive, especially in pro bono and public interest related work. The truth is, if you're coming into law practice, prepare for one eventuality, not an eventuality, prepare for a fact that early law practice has no financial reward, little or no financial reward. Get that clear. Unless you are the scion of, you are a child of wealthy or upper middle class parentage, or your parents are lawyers.
Just to get that right, you said any law practice does
Early.
Yes. Okay, right.
Early law practice.
Okay, right.
From the day you are called to bar, in the first 5 years, perhaps even the first 10, if you're not in governmental or corporate employment, if you're in litigation, there is little or no reward. And it's not a Nigerian phenomenon. It's everywhere. It's in the UK. It's everywhere. So the only thing you can say to young lawyers is the advice which Zeke gave when he was asked what are his final words to Nigerians when he was celebrating his 80th birthday or 90th birthday, and he says his advice is surulere. You can only advise young lawyers that you've got to give yourself to the profession to grow and be long-suffering. Don't expect financial reward. That is the truth. I was once a young lawyer. I've been practicing now, thank God, this is 34 years of practice.
I'm not sure that...
And I didn't have... it was excruciating in the first few years, but I stayed at it. I stuck to it. I practiced, and I picked up skills. Let every lawyer decide that the first 10 years is for picking up skills. In the evening of your career, you will excel.
I'm not sure that surulere message, that patience is virtuous, is something that many Nigerians want to hear now.
But I think it's true. It's only fair to actually pass that message across.
Yeah. And that's a message to every young lawyer and to every Nigerian.
Now, to going to the every Nigerian, many believe that they have been dealt the wrong card over the past few years, in terms of the economy and all of that, the way things are generally. I'd like you to weigh in on the subject of setting agenda for, governments at various levels, federal, state, local, but maybe particularly the ministers who have just gotten into the saddle. What must we do now to jumpstart quick action, quick development, quick wins for the Nigerian?
You can see I'm taking my time to answer this because the country is in a bad shape. It's in a very bad shape. And even though you cannot lay the burden of the condition of this nation squarely on President Buhari, it is the desolations of many generations that we are seeing here. It has come full cycle. But the last 4 years did not show us an administration which had the capacity, the intellectual insight, the vision to move Nigeria to the next level. And I must say that with few exceptions, the ministers are discouraging. You will have thought that in the last term of this administration, they will go and pick up some technocrats. But they did not. It was the same old. And Obasanjo, who, in my view, is the most successful leader Nigeria has ever had, 1960 till date. What was his secret? What was his trick? The quality of some of his key ministers. We heard of certain names for the first time. Obi Ezekwesili, Ngozi Okonjo-Iweala, El-Rufai, Nuhu Ribadu, Charles Soludo. We heard about some of them for the first time under him. And then under Jonathan, you find Akinwumi Adesina emerging on the scene. And perhaps his area is perhaps one of the very few areas you can say that administration achieved in. So with few exceptions, this is a mediocre cabinet. And you're asking me to set an agenda for them. The agenda is, we have no more time. We need to get started like yesterday. Key things. If you want Nigeria to move forward, you've got to restructure the country and devolve some of the federal powers down to states and LGAs. But then somebody will always ask, how about the states? Are the states doing well? You're talking of restructuring and devolution. The states are not even doing well. It's a national malaise that mediocrity rules in the land. But I will say, I've mentioned restructure on a political platform. On a developmental platform, we've got to ease up the economy. And my view about that is, whatever it will cost to get rails working all over the country, because transportation is like the arteries in the body to carry goods, to carry the blood from one point to the other. So without, the economy will be revived if electricity supply and the transportation network, and I'm emphasizing on rails, not on roads, because you fix the roads and next week they are bad again. Once transportation network, rails, for easy movement of goods and electricity is resolved, then just go to sleep. No. The entrepreneurial dynamism in Nigerians will come to the fore.
It's interesting. You've talked about the transport ministry, you've talked about power, you've talked about the economy. But let's come to your area of jurisdiction, which is in the judiciary, in the Ministry of Justice. Now, we've had cases. In fact, yesterday, I remember your learned colleague talking about cases of disobedience of court order and then the rule of law. So let's sort of set an agenda for this, the Minister of Justice and the Ministry of Justice. We've had cases time and again of people saying this government perhaps is not looking the side of court. I mean, you have orders and it appears these orders are disobeyed. So what should be done to ensure we don't have a repetition moving forward?
My message to Attorney General Abubakar Malami, Senior Advocate of Nigeria, is rule of law should never be subordinated to what you call the national interest, because the national interest is a subjective and amorphous phrase which will change from one head of state to the other. National interest, in the opinion of one head of state, could be my own interest. Anybody who opposes me is opposing the national interest.
Is there a way to define national interests?
In my view, it is subjective. What is national interest? What you call national interest may not be what I call national interest.
But I don't know what the Supreme Court...
somebody may say that because I say the country should be restructured, it's not in the national interest. I am a secessionist. And somebody else may say, oh no, that's in the national interest.
Again, we may need to define that,
Yes.
Mr. Akari, because you remember, of course, you know this better than I do, the case between the federal government and Asari Dokubo, where the Supreme Court ruled that where the national interest is concerned, the personal or human interest is subjected. So how do you respond to that?
Well,
again, that is the view of the Supreme Court.
Well, and the view of the Supreme Court binds all of us. The principle of stare decisis. We are bound by it, but what we are saying is that decision opened a can of worms. What we are saying is that we hope that decision will be reviewed and set aside when an appropriate appeal will come before the learned justices of the Supreme Court, because national interest is too amorphous and too subjective, and that is why...
So you are asking for a definition of the national interest?
I'm not asking for a definition. I know the definition. The national interest is what is in the interest of the nation. To give a very trite and pedestrian definition, whatever is in the interest of the nation is national interest. And I'm saying that this is too subjective. So the rule of law, the rule of law is the fulcrum of civilization.
So maybe the body of lawyers might want to push a case that would at least help with the definition. Because you said it, that you're waiting for an appropriate appeal that would eventually now sort of define this. So why don't we have a push from the body of lawyers?
Well, yes, I can bet you that there are appeals are going up to the Supreme Court every day. Appeals are going up every day to the Supreme Court. And the Supreme Court will, I'm sure, soon be faced with an opportunity to revisit the decision in Dokubo. But let me just say this. You talked about disobedience to court orders. We can't live like this. We can't live like this. This is dictatorship. The rule of law is the guiding and fundamental principle for civilization. The court cannot say, free this man on bail, release him on bail, and you refuse to release him on bail. You cannot subordinate a court's pronouncement to review by individuals. Okay. This is wrong. So what should happen is, if the court gives an instruction to release a person on bail, obey the order of the court, even if it means that you're going to rearrest him 3 days' time.
Let's take this one very quickly. Emeka Namani sends this and says, do the NBA have powers to stop any member from practicing? Some lawyers have said that the NBA is just an association and cannot dictate what they should do.
Oh, yes. We have lots of cases before the Legal Practitioners Disciplinary Committee, which is set up in pursuant to the rules of professional conduct. And lawyers have been stopped again and again from law practice. Lawyers who misappropriated clients' monies and different scenarios. It's happened again and again. The power is there, and it's just for you to report. Or once a proper report is sent to the General Secretary of the Bar, he sends it out to the relevant organ, and they begin to investigate. And when a prima facie case is established, they take it on to the next level. Incidentally, Mr. J.B. Daudu is the chairman of the panel, the disciplinary panel of the Nigerian Bar Association.
So what do you say to lawyers who said that the NBA is just an association and cannot dictate what they should do?
Well, these lawyers are perhaps not aware that if a petition against a lawyer comes to the NBA has the teeth to push the petition to the relevant organ, which will dispassionately look into the matter. And the person may either be discharged, acquitted, or convicted. So that is not right. The NBA is not as helpless as that. But I will only say that we, again, need to expand the dynamism of our disciplinary apparatus. Something needs to be done. I think that the numbers of persons who are convicted, who are sanctioned by the NBA disciplinary mechanism are too few.
It could be more.
It could be more with respect to the amount of infraction that's actually going on. We need to also, there's also a need for us to redefine and recreate the association, no question, that facing the future, which is the theme of the conference, if we are to face the future adequately, effectively, effectually, we must get our disciplinary mechanism much more effective, swifter, and dynamic.
And perhaps the discipline should start from the school, because that means that perhaps the courses that lead a lawyer to becoming a lawyer also need to be reviewed.
Certainly, one area Council of Legal Education must look into is professional ethics. Professional ethics is taught for 1 year in the law school. It should be taught from first year in the university. That is my view. Every year, for your 4 or 5 years in the university, you should take a component of professional ethics till you graduate, so that ethical behavior and conduct can be ingrained into the lawyer when he's still 17 years old, when he's 18 years old, 19.
All right. Well, thank you very much for being a part of this conversation. Mr. Ikeazor Kariwe is a former chairman, NBA Human Rights Institute. He is former first vice president of the NBA, as well as the Conference Planning Committee, NBA SPIDL. Thanks very much once again for being part of this conversation.
Thank you very much. I came here last 5 years ago, August 2014. Wow. So I'm happy to be back here 5 years after.
Exactly 5 years after. Thank you so much.
All right, we'll be back in a moment for more. Stay with us.